The broadcast is now starting. All attendees are in listen-only mode.
Good afternoon, everyone. It's Andrea Sparks with the Governor's Child Sex Trafficking Team and Todd Latiolais, who is our Prevention and Policy Administrator. And we are delighted that you're here for our legislative update. What an amazing regular session we had on human trafficking, something we didn't really expect. But the Human Trafficking Task Force, the statewide task force, did a really good job of getting all the stakeholders together, getting some good priorities lined up, and then just really working hard to get advocates to the Capitol to testify. So many of you on this call were part of that, and we appreciate it either in person or via Zoom with the testimony and just getting the word out to your legislators. We have about 350 people registered for this webinar. It's typically one of our most popular, and only about 164 are in right now. So we're going to get ready to start in about, I'd say, 60 seconds. But usually our webinars are an hour. I think we're going to go a little over today just because there is so much to talk about, and we want to get to your questions like we always do at the end. So at the end, we'll reserve a little time for you to send a question via the question box. And we will be monitoring those and answering those to the best of our ability. Also know that this is being recorded, and unless we really mess it up, we're going to have it available on our website for others to watch who couldn't make it today. So without further ado, I guess I'm going to go ahead and introduce Todd. Todd Latiolais is our Prevention and Policy Administrator at the Child Sex Trafficking Team at the Governor's Office. He's been with us since the beginning. In fact, I was about to hire someone else in this role and found out he was potentially interested. And I remember I stopped my car in the middle, not in the middle of the highway, but on the side of the street, and called him and said, "Are you really interested in this job? Okay, I'm going to have to undo all this paperwork, but if you're interested, let's get you in here." And I'm so glad we did. He is our resident lawyer. He is, I call him my general counsel. He's just really, really smart about all these issues and does a great job of making legislation and law kind of fun to listen to. So Todd is going to give you all the updates, and as I said at the beginning, if you have any questions, just put them in the chat box or send them in the question box, and we will get to them probably at the end. Todd, you think you're going to go for about an hour and 15, an hour 30? What do you think?
Probably just over an hour, I hope, maybe 1:15.
Okay, awesome. All right.
Thank you, Andrea, and thank you, everybody, for being here. I'm always very humbled when we have such a great turnout for these legislative webinars. My experience in the past has been that people are always really excited when there's a legislative update at a conference or a webinar, and then they get there and they're like, well, this is a lot more boring than I anticipated to hear about legislation. So I hope that's not the case today. I'm going to do my best to make these updates as accessible and sensible to you as possible. And despite all of Andrea's kind words about my interpretation, I do want to just give the caveat that I'm actually not your general counsel or anything like that. This webinar, the focus is just to provide an update on bills that were actually enacted and made it into law during the regular session that recently ended. So I might add a little extra commentary that is just my own interpretation and read on it. It's not necessarily a formal legal analysis or statement from the Office of the Governor, just sort of my take, having been in this space for quite a while. A couple other housekeeping things, as Andrea mentioned, your phones are muted to help this go as smoothly as possible. My GoToWebinar is pretending to freeze, so hopefully that doesn't prevent a recording. But assuming the recording goes well, we'll have that up on our YouTube and shared with all of you. We don't have them here for you today just because of some technical glitches, but we have a couple of handouts that will also be shared with you whenever the webinar is shared later. That is more of a comprehensive table with some brief summaries of legislation that passed this session. So I just want to let you know that, that handout will be coming to you as well. So with that, we'll dive in with a little bit of background and context. I wanted to share that trafficking is not a new issue in our state or in our country. A lot of you that work in this space realize that it was the year 2000 when we had our first federal flagship legislation, the TVPA, Trafficking Victims Protection Act, in our country. And just a few years later, in 2003, Texas passed its first trafficking against persons statute. So we were an early adopter. I think there were only 2 states at the time that had trafficking laws on the books. So we were one of the first to actually be in that space. And things have changed a lot since 2003. As you can imagine, this crime continues to evolve. The way that it's perpetrated continues to evolve, and our understanding as a state continues to change as well. So we're always trying to keep up with the trends, reflect those changes in our laws and our policies. For example, when the law was first passed in 2003, transportation was a key element of the crime. People had to literally be trafficked, transported in the common sense of the word traffic. That is not the case anymore in our state or under federal law. Somebody can be trafficked without ever being moved from place to place. So there's going to be a lot of words on this slide because I'm a lawyer and I can't help myself, but I did just want to start with a baseline of what is trafficking in Texas. And first I wanted to highlight that trafficking is not just perpetrated by the traditional pimp or trafficker. Yes, that is one party to the crime of trafficking. If a person is actually the one to traffic a child and by any means causes that child to engage in commercial sexual conduct, so any sexual activity where something of value is exchanged, commonly money, but also other things that have value like food, shelter, concert tickets, clothing. If anything of value is exchanged and that person is under 18, they are a trafficking victim. They cannot consent to their own exploitation. So the person that actually made that happen can be charged under the trafficking statute, but you often also have people that benefited knowingly from that activity. They turned a blind eye or they supported the transaction in some way. They can also be charged in Texas under our trafficking statute. And finally, our statute says that if you are the person that engaged in sexual conduct with that trafficked child, you can also be charged under 20A, which is our penal code statute for trafficking. So all of those people are complicit in the crime. And what actually makes up the crime of trafficking? Again, a lot of words because I'm pulling from the penal code here, but you can think of it as 3 main elements for all forms of human trafficking. First is the action of trafficking. What does traffic mean? It means that somebody maybe was transported, though not a requirement. Maybe they were recruited somehow. Maybe they were enticed. Maybe they were harbored. Federal law also says patronized to capture the buyers. Any of those things could be the action for trafficking. Then we have the means or the cause of that trafficking. For other forms of trafficking, labor trafficking and adult sex trafficking, that causes force, fraud, or coercion. So the perpetrator had to use force, fraud, or coercion to achieve what result? A commercial sex act for sex trafficking or labor and services for labor trafficking. And so again, I pull all of this just to give the very important caveat that when it comes to minors under 18, there is no requirement of force, fraud, and coercion. So again, if a child is transported, recruited, harbored, maintained by any means, and they become the victim of any of this conduct that you see here, we could have a trafficking arrest and charge on our hands. Also, a little additional background and context, like who is this child sex trafficking team? A lot of you have followed us for a long time. As Andrea mentioned, we've been around just over 5 years now, and that's because our team was created in statute just over 5 years ago during the 84th session. And so when the legislature created our team, they housed us in the governor's office. We exist in the public safety office, and you can see here just language I have pulled from the government code, which gives us a very comprehensive and holistic charge. We are responsible not just for improving victim identification and access to immediate services, but also facilitating long-term services, long-term advocacy and case management, all the way upstream to preventing this from happening in the first place, and also supporting criminal justice efforts. So that's a lot, and we are a team of 10 folks at the moment. So a lot of the work that we do is based around collaboration and coordination with state agencies, but also nonprofits, service providers all around the state. And we wouldn't be doing our job as good Texans if we didn't convert that legislative charge into a Lone Star. So you can see this is how we visualize a lot of the work we do around each of those strategies: protecting, recognizing, providing support, and bringing justice. Every one of those strategies we want at all times to be child and youth centered. So we don't want to engage in strategies that perhaps improve recovery or improve justice, but don't meet the needs of that child and youth and put their needs first. So we're always keeping an eye on that. And I also share this star to show you, this is how we're going to be walking through a lot of the legislation today. I'm going to be giving you some high-level overview of some things that were recommended by the statewide task force, and then I'll walk through some specific provisions based on how they sort of fit into this framework of our star. Finally, relating to our team, I wanted to point out that all of that work to improve prevention, to bring justice, to improve victim identification, we have folks who are on the ground, our regional administrators. You can see the regions that they cover here are quite large, but their role is to be a liaison from our team to provide support locally, to look at the continuum of care, to identify gaps that may exist among that continuum, and to help us to fill those gaps and develop sustainability for all of these issues. And you will see at the very end of the presentation, if you're not familiar with the RA or regional administrator in your region, I'll have their contact information on the last slide. They are an excellent resource for you if you're trying to figure out how to plug in your community or who some of the players are in those different strategic areas. Now let's dive in and talk about some legislation. Again, I'm only going to be talking about things that actually passed, but I did want to take a moment. A lot of you have probably seen Schoolhouse Rock, and you know how difficult it can be for a bill to make it all the way to the finish line. So this past session, we had over 6,900 House and Senate bills that were filed to make their way into potential legislation. That number is actually quite a bit larger if you include other resolutions. It's, I think, 9,999. We couldn't just get that one more for 10,000, but just looking at House and Senate bills, over 6,900 bills. And as you can see, it is a very small number of those bills that ultimately passes and becomes law in our state. And I want to point that out because I think we know that this session was unusual. This session was historic in a lot of ways. It was challenging in a lot of ways. There were a lot of complications going into session between the pandemic. We all remember the winter storm that happened early on in session, other disasters. So this session was a little unusual, and I think the numbers play that out a little bit. But what I was surprised by was, given those challenges and given the complications of making it into law, just how many bills passed that are going to impact the issue of human trafficking. So I think we should all be very pleased that that is the case, that there were so many good laws that passed related to trafficking. Before I dive into those different strategic areas, I want to acknowledge the work of the Texas Human Trafficking Prevention Task Force. This is a task force that's chaired by the Office of the Attorney General. It has actually existed since 2009. The initial chair of that task force was the then acting Attorney General, Greg Abbott, who is obviously now our governor and my boss. He was the first chair of that statewide task force, and it exists again in statute. And it has a number of responsibilities, from collecting data to providing training to facilitating coordination among state agencies. But one of those responsibilities is providing legislative recommendations back to our state legislature when they reconvene every other year for the legislative session. And so I want to talk about the recommendations that the task force made briefly, and then we'll dive into a few of them in a deeper level. So what you see here is a list of the recommendations that the task force made to the 87th legislature, and they can be bucketed into three basic categories. So the first and largest category is actually basically statutory cleanup. There are so many bills that are filed every session, and sometimes they are passing in the night and amendments are made, and unintentionally there can be small conflicts that come up in our codes as a result of that, or maybe unintended consequences that just need a little bit of clarification. So this first category of bills really is just cleaning up what's already on the books, making it more functional. And I'm going to share a little bit, really just the first one there. The others are primarily cleanup bills. The second category of bills are aimed at are bringing justice, basically, supporting investigative and prosecutorial tools. And we'll discuss both of these recommendations that did make it into law in just a bit. And then the third category was geared around improving protections for victims. I should have mentioned this at the beginning, but a lot of the language I use in my presentations is based around statute and code. So of course we recognize that these individuals that have been exploited are survivors of their experience and their exploitation. So I'll use those terms often interchangeably, but a lot of that is because of the language of the code around victim-centered protections. So there were three recommendations around victim protections, and as you can see, there was only one that didn't pass that had to do with victim testimony that would be admissible in court proceedings. And so all in all, a good session for the task force recommendations. All but one recommendation ultimately made it into law. Several of these actually were filed in different bills at the beginning of session, but by the end of session, most of them made it into one large omnibus bill, and we'll talk about that now. So if you have heard reference to the task force bill, talking about the statewide task force, people are probably referring to House Bill 1540, and that was filed by Representative Senfronia Thompson out of the Houston area. She has been a champion for a long time and has historically been the one to file a lot of these task force recommendations over the years. Senator Huffman and the Senate side also from the greater Houston area has also filed a lot of these recommendations on the Senate side. So what you see listed here are all of the task force recommendations that ended up making it into this omnibus bill. So there were actually, I guess, 8 of the 9 recommendations that passed were in the omnibus bill. There was one recommendation around sexually oriented businesses that also passed, but in a different bill. I also wanted to share that there are sometimes other things that get added along the way in the legislative process. So if you were to review House Bill 1540, you would find that there are a few things in there that actually were not task force recommendations, but passed using that bill as the vehicle. The first is the creation of no trafficking zones around schools, which actually passed in 2 different laws. And the other recommendations had to do with the use of survivor pseudonyms, one in civil cases against their traffickers, and the other actually in testimony to legislative committees. One of the most inspiring things about session for me has been watching advocates of all walks of life come to the Capitol and support pieces of legislation that they think are impactful. And there have been so many survivor leaders that have really stepped up as advocates. And there are many of those survivors that are comfortable being out there and having people know who they are and their story, but some want to participate in that process and are just not there in that public facing light. And so this provides an opportunity to use a pseudonym for those that would like to do that during the legislative process. So finally, let's get into some of the nitty-gritty of some of these pieces of legislation that passed. First, I'm going to talk about those laws that have to do with either protecting individuals from being exploited or improving our ability to recognize them, raising awareness, improving the identification of victims around the state. So first is a couple of laws that passed related to sexually oriented businesses. There has been a lot of advocacy around this issue for the last couple of sessions. You may hear people referring to this package of bills as the SMART Act. There were some versions that used that language as an acronym for these bills. That's what these are referencing. But basically, these two pieces of legislation, both filed by Senator Huffman, impact protecting children and youth from potentially being exploited in sexually oriented businesses around the state. The first bill was Senate Bill 315. This was actually the task force recommendation around SOBs, is how we refer to them for short, sexually oriented businesses. And so in the task force recommendation, it raised the age of eligible employment in these businesses. So prior to this, an individual could work in an SOB once they turned 18. Under this new law, they would have to be 21 to be hired by an SOB. And a lot of people mistakenly believe that SOBs are only strip clubs. They are one type of sexually oriented business, but there are a number of other SOB business models whose primary purpose is some sort of sexual arousal. So there are, for example, adult video stores around the state that would fall into this category as well. What that law also did, besides raising the age of employment, is prohibits those businesses from allowing minors under the age of 18 on the premises. And it also said that if they allow minors onto the premises, that could result in a TABC violation. We know that for a lot of these clubs, a lot of the money coming into the club is not just the sales that are happening in the book and video stores or the dancing that's happening, but also the alcohol sales. And so I believe the legislature thought to penalize these places for making a profit and hit them where it hurts. They want to have possible suspension or cancellation of those alcohol permits and licenses for violating allowing minors on the premises. So that portion of regulations actually went into effect as soon as it was signed. It was passed unanimously out of both chambers, and the language of the bill said it would take immediate effect upon signing. The governor signed that bill on May 24th. It was just a few weeks later, I think June 15th was the date, that a federal lawsuit was filed seeking to challenge that law. At the last I looked at the docket there in that federal court, I believe there's a hearing tomorrow, Friday actually, on whether or not there would be an injunction actually placed on that law, meaning that state law enforcement would not be able to enforce those regulations until that lawsuit plays itself out. So we will see if that's going to be stayed for the time being, but it did go into effect on May 24th. There was a second piece of legislation that really went hand in hand with Senate Bill 315 that will go into effect in September when a lot of our state laws go into effect. That was Senate Bill 766. So it had a lot of the same provisions as Senate Bill 315, but it also added a couple of other provisions. First was requiring those businesses to participate in E-Verify. So those that have worked for certain companies or are involved in employment law or HR, you might be familiar with E-Verify. It's a federal system to basically verify employment eligibility. And the thought process behind that was making sure that those SOBs are doing their due diligence to ensure that that person is eligible and of age to be working in those establishments. What it also did was added an additional alcohol and beverage violation for those that actually hire someone under 21. So if they are violating the law, not just by allowing a minor on the premises, but actually employing someone under the age of 21, that would be an additional reason for suspension and cancellation of their alcohol permits. Of course, this also touches on other laws around labor and employment. We have a statute in our state that's actually tied to our trafficking statute that is employment harmful to children. So anybody violating this would not only be subject to, administrative and alcohol permit suspension, but actually also criminal penalties for violating that law for employment harmful to a child. The next provision that deals with protecting youth, what was also a task force recommendation, and this one passed in House Bill 1540, that omnibus bill, has to do with GROs that are operating as residential treatment centers, so RTCs. And basically what it does is it designates RTCs, these treatment facilities, as child safety zones, gang-free zones, and drug-free zones. So child safety zones, you might be familiar, those are basically areas and locations that certain people that are on probation have to avoid. So it's basically, if you are on probation for certain offenses, including trafficking, these would now be part of the area that you are no longer allowed to be within the vicinity. Gang-free and drug-free zones are something that exist as an enhancement for certain drug and gang-related crimes. So if you commit a drug or gang-related offense in one of those zones, you're subject to enhanced penalties. And so these are now also drug-free and gang-free zones. So if that type of criminal activity is happening near an RTC where we know there are vulnerable youth, those perpetrators could be subject to enhanced fines. RTCs now will also be incorporated in our state's criminal trespass statute. So those that are not meant to be on the premises could be subject to criminal trespass. And to put them on notice, RTCs are going to have to actually post no trespassing notices in our state. Health and Human Services Commission is going to be helping develop that signage for those RTCs. And finally, there is actually an enhancement under our trafficking statute if the trafficker was recruiting, enticing, or somehow luring that victim from a residential treatment center. It also identifies some specific centers serving high-risk populations. So, for example, runaway and homeless youth, DV shelters, programs that serve foster children, traffickers that are using those as sites to identify victims could be facing enhanced penalties. I should point out that it actually is already a first-degree felony in the state if the victim is a minor. But if somehow you had a young adult being served or a transition age youth being served by one of these facilities, that penalty now would match other child sex trafficking. Next, this provision, schools as no trafficking zones. This was one of those that you may remember was not a task force recommendation, but actually made its way into the omnibus bill, 1540. It also passed under a separate Senate bill, which was 1831 by Senator Taylor. What this provision does, remember how I discussed drug-free and gang-free zones and how you can face enhanced penalties in certain areas if you commit those crimes? It basically models that and does the same for trafficking. So it would make public and private schools and a certain perimeter around those no trafficking zones, so that if an individual is committing certain trafficking or related prostitution offenses, such as promotion and compelling prostitution that are closely tied with trafficking, if they commit that crime within that zone, they will be subject to an enhanced penalty. So you can see there, trafficking of persons in that zone will automatically be a first-degree felony, even if it otherwise wasn't. Solicitation, so buyers that are seeking to purchase prostitution, that's actually a new statute in our state we'll talk about in a little bit. They would face one-level penalty enhancement. And then finally, online solicitation of a minor, which is kind of interesting because it's an online facilitated crime, so you're not necessarily in that zone around a school. But the language of the law says basically if that alleged perpetrator knew or should have known that at the time of that offense, that child should have been enrolled in school, and in school, then they could also be subject to those enhancements. So that one's kind of interesting. It will be interesting to see how that plays out with prosecutors. It is also potentially implicated by the fact that we have compulsory attendance laws in our state. So I think given certain school hours, we could argue that you basically should always know, based on those compulsory attendance laws, that that child should have been in school. But it's just another way to protect youth from this type of activity happening near our school campuses, both public and private. And finally, and I skipped over it as I talked about enhancements, schools will actually be required to post notices. So you have probably seen signs like, this is a drug-free zone, this is a gun-free zone, this is a gang-free zone. There will now be similar signage around no trafficking zones around schools in our state. Another way that the legislature sought to protect vulnerable individuals, and this one I found really interesting, was not a recommendation, but just an idea that passed during session, was House Bill 375. And basically what House Bill 375 seeks to do is provide additional protections for those youth and young adults who have serious disabilities, intellectual disabilities. They actually point to a language of disabled individual that you see listed there. It's basically anyone older than 13 that doesn't have the capacity to consent for whatever reason, whatever that underlying disability might be. So in our state, we already have a statute that addresses continuous sexual abuse of young children. It creates enhanced penalties for those that engage in that type of abuse against particularly young children. And the thought process for the author was there are older children and also even adults that may not have the capacity to consent or to protect themselves, and they should also benefit from that same level of protection. And so I included that here because the statute also specifically identifies sex trafficking as one potential form of sexual abuse. So if you have a disabled person that is being abused through sex trafficking, they could be prosecuted under this statute, which would automatically be a first-degree felony that could be subject to life imprisonment or 25 to 99 years. Shifting a little bit from those more protective related bills, I wanted to talk a little bit about awareness in our community. So what you see here is actually a historic picture of laws around training and awareness in our state. So all of these existed prior to this session. Each of these blocks represents a sector or profession or group in our state that has either legislation that requires awareness to be made available, legislation that requires training to actually be taken and tracked, or requires awareness posters to be posted that point up until this session to the National Human Trafficking Hotline, to a resource center to get help for survivors. So you can see we already, before this session, had a lot of groups that were implicated by that training, mandatory training for educators, 1 hour training for healthcare practitioners, training for salons and cosmetologists. But also some of those locations have to have signage as well. And so I wanted to highlight some of that after we talk a little bit more about training. So what you didn't see on that last slide was hotels. This is a brand new provision out of House Bill 390 that actually is going to create mandatory training for hotel employees. So this is going to apply to hotels that have at least 10 rooms. So it's not going to be like your small Airbnbs and that sort of thing, but it's going to create mandatory training that has to be at least 20 minutes. There's going to be a process by what the Office of the Attorney General will approve those trainings, but all hotel employees will have to go through that training, and there's going to be some rulemaking that's going to have to take place, but ultimately by next January and the start of the new year, hotels will be having to implement this new and approved training program for their staff. And I don't think we need to go into a lot of detail about why this is a target population for training. You have here a quote that I pulled from a report that Polaris did. Polaris is the nonprofit that runs the nationally funded National Human Trafficking Hotline. They had a report that looked at all different sectors that connect with trafficking, and they found hotels, not surprisingly, as one of the key places where victims of trafficking, both sex and labor, but predominantly sex trafficking, often had interaction with during the course of their exploitation. I also wanted to point out, there is also the possibility of local regulation around hotels and lodging establishments. The city of Houston actually was one of the first cities in the country to pass a local ordinance that requires training around human trafficking. And so the bill was also really clear that it does not preempt local ordinances that may be more restrictive even than the state ordinance, than the state statute would be. So if there are other cities that are exploring ordinances similar to the city of Houston, they do still have that possibility. I mentioned that our state has laws both on training and also signage. So hotels will have signage under the language of the law. It's probably not going to be a sign that you see as a customer of the hotel. It's actually employee-facing signage. So it's a sign that employees will see that will educate them about trafficking, remind them of these requirements. And those employees will also have whistleblower protections if that hotel is not providing training, if they're not posting signs, that sort of thing. That report can be made. There could be civil penalties enforced. There could be injunctions that are made from the state for that, but those employees do have protections under the law. In addition to trainings, like I said, there are a number of places that have to have signs. So what you see here is a number of places that under state law are required to have signs and posters about human trafficking on their premises. Historically, these posters, and they all have different language based on the agency that implements or the language of the statute, but pretty much across the board, all of these signs historically have been focused on, if you are a victim of trafficking, sex, or labor, if you know someone that's in need of services as a potential victim, here is a national hotline that you can contact to try to get in touch with services. And every one of these historically has pointed to the National Human Trafficking Hotline. They really are the resource nationally that's available to connect individuals with services in their areas. What these signs didn't always do was encourage people to report trafficking if they suspected trafficking to be happening. Some of them did, some of them didn't. The National Human Trafficking Hotline can accept tips and connect them to local law enforcement, but it's not necessarily what they were created to do. And there are a lot of limitations when they do receive those tips and how they can make connections among those tips. For example, if similar calls were to come in about activity that happened in Beaumont, but then also happened in Houston, sometimes there's limitations on that nonprofit's ability to make connections among those tips. So there was a bill that was passed, House Bill 3721, and this had a lot of conversation from our statewide coordinating council, which is a core steering committee of that statewide task force, to say, how can we improve not just survivors getting connected to services, but also the general community making reports of this suspicious activity. So each of these sign requirements has now been updated in our code to not only have information about contacting the national hotline for access to services, but also contacting the Department of Public Safety through their suspicious activity reporting system to make those reports of suspected trafficking. Again, you know, individuals could continue to contact local law enforcement, they could contact federal partners, they could contact the national hotline. Those are all still options, but having this more uniform language around our statewide suspicious activity reporting will improve the ability for us to make connections among those various tips in our state, and DPS will be able to work with local law enforcement to farm out those tips that come in and to help make connections between various jurisdictions. So what you see represented here, all of those darker colored blocks, those are signs that already existed in Texas and have now just been updated to include the suspicious activity reporting. That last line across the bottom, those are actually new signs that are going to be required as a result of Senate Bill 1831. You might remember that was the no trafficking zone bills, but this was some signage that got added onto that. So brand new after this session will be tattoo studios that are going to have posters, gas stations with adjacent convenience stores, Texas state parks and recreational sites, and then as I mentioned, hotels will have that employee-facing sign. The last thing that I wanted to mention about this, and I kind of already alluded to, currently every one of these signs is different. They might have some similar language, but they are different sizes, they have different content, they have different verbiage on them. And so one of the other things in Senate Bill 1831 was that they wanted to consolidate those. So they pulled those signs together in statute instead of existing in, you know, a dozen different places. And they also gave discretion to our statewide task force and coordinating council through the Attorney General's office to create some model signage. So we could have signs that are more in alignment with one another. It's not mandatory that that model sign is used, but each of the state agencies that enforces these, for example, HHSC looking at hospital signage, TDLR looking at cosmetology and massage signage, they will have the discretion to allow their providers to use that model sign. This is also something you want to keep in mind if you are somebody that is doing outreach and training around trafficking and you've only ever considered reports to the National Human Trafficking Hotline, and there will be times that that is the place that makes sense for certain individuals to make a report, but also being aware of this new language around DPS and suspicious activity reporting as well. Okay, shifting gears a little bit away from protecting and recognizing, I want to talk more about some victim-centered legislation that passed this session, either recovering individuals in exploitation or connecting them with healing services. So first of all is House Bill 2633. This was filed by Representative Ann Johnson from the Houston area. If you have been in the anti-trafficking space in Texas for very long, you may know her as a champion around anti-trafficking. She was in the Harris County DA's office for a long time, prosecuting trafficking cases. I got to know her originally because she actually was the attorney that represented a young individual who is identified as BW in that litigation when her case made it all the way to the Texas Supreme Court. And that is the case that basically held in the state of Texas that young children cannot be charged with prostitution because they are the victims and not the perpetrators of that crime. So she has been around this space a lot, even though she's new to the legislature. And she was really passionate about creating dedicated funding specifically to support housing for survivors, had concerns about youth that are vulnerable, that are being mixed with other populations, also kids that are potentially dual status in multiple systems. And so this bill creates a new funding stream that didn't exist in our state before. May take a little bit of time for that account to accrue funds because it's funded really on voluntary contributions. So if you have seen specialty license plates around our state before, those typically are used to raise funds for different causes. There will be a new specialty license plate themed around stopping human trafficking, and the funds for those plates will go into this account. Also, there will be options as individuals are updating their vehicle registration or updating their driver's license applications. There will be that option to make a voluntary contribution. And then there will also be the ability for private philanthropic dollars to flow in. Specifically, we had a program created a few sessions ago, around the same time our team was created, that our Secretary of State would have a statewide business partnership for businesses interested in addressing trafficking. And so this bill also contemplates that those businesses that are part of that partnership could get involved with this and help raise awareness and funds for this new account. Again, this account is meant to be used primarily as a grant program dedicated to housing and treatment facilities for survivors of trafficking. The law does identify just a few other areas that could potentially be eligible under these account funds, but all of them have some nexus to rehabilitation and housing for survivors. So again, the priority being that dedicated housing, but they also identified treatment programs that are operated by medical facilities. That was legislation that was passed in the 86th session. Also some juvenile specialty court programs that already exist around the state would make some funding available to them and would also allow our Health and Human Services Commission to get more involved in seeing that these facilities actually get off the ground around the state. Also, and I'm going to spend not a lot of time here because this gets complicated in a hurry, but there was a very sweeping omnibus bill that had to do with our state's foster care system, and that was Senate Bill 1896, filed by Senator Colcourse. You could look at that. It is so long. It addresses so many different issues, but I flag it for you only because there is a provision of that large bill that touches on trafficking specifically. I don't know how many of you are familiar with the Family First Prevention Services Act of 2018. It's a federal law, often referred to as the FFPSA, but that basically also was sweeping federal reform around state foster care and child welfare systems all around the country, really trying to improve flexibility of those systems, but also to decrease the amount of kids that are in more congregate settings, try to have more family-like settings, but it also had some implications for victims of trafficking or those that are at high risk of trafficking. So some provisions in this state legislation dealt with implementation of the FFPSA, and a subset of that had to do with trafficking specifically. So I've identified some of those on the slide for you here. Our state Department of Family and Protective Services is tasked specifically with looking at placement capacity for trafficking survivors and those at risk of trafficking around the state. The legislation also requires the agency to look at nationally recognized tools that could be used in that process. It specifically actually calls out a tool that we refer to as the CEIT, the Commercial Sexual Exploitation Identification Tool. That's a tool that's currently being used around the state to screen young people for potential trafficking. We know that youth who have been exploited as trafficking victims by and large do not self-identify, and they don't outcry as trafficking victims. So it's a proactive screening tool to improve victim identification. And finally, it says, as we're seeking to expand that capacity, the providers that are building that capacity need to meet certain standards and requirements around trauma-informed care and minimizing high-risk behavior such as runaway behavior, and also having really quality, comprehensive case management services. I did want to highlight just a couple of other bills that also fell into this same vein of supporting victims. And both of these have to do with increasing access to dollars to support victims. First was House Bill 402 by Representative Hernandez. This basically deals with civil asset forfeiture and how those funds can be used. And it says that if there is a trafficking offense that's taking place and there is contraband that is seized, that you can actually use the proceeds from those seizures to then reinvest in victim services in your community. So those are city or county level programs aimed at serving survivors of trafficking. So again, that would be contraband specifically from that was being used to further an offense of human trafficking. We're going to take that and then have the option to reinvest it into victim services. The other was a Senate Bill 957 by Senator Zaffirini. This has to do with CVC, or Crime Victims Compensation Fund. So there are a lot of rules around how CVC funding can be accessed. This is just one small provision that was aimed to improve the experience of survivors in drawing down these funds. There's a rule and a law that basically says if a victim of sexual assault or trafficking, a victim of crime, is not cooperative with law enforcement, the Attorney General's office that administers those CVC funds can deny or reduce payment to those victims. So basically says your payment could be reduced or denied if you don't cooperate with law enforcement in relation to the crime that was committed against you. Recognizing that a lot of victims, especially of trafficking, at that moment, especially of recovery by law enforcement, are often in a place of serious complex trauma and not willing to cooperate, not willing to maybe even speak with law enforcement at the time. This bill basically seeks to not penalize those survivors for that point in time at that initial recovery for not speaking or being cooperative. So it says that that cannot be a reason for reducing or denying payment under CVC. Finally, getting into our last section around bringing justice. These are all provisions that have to deal with our law enforcement and justice system response to trafficking and related issues. And several of these are provisions that you will have seen earlier that I identified as task force recommendations. First, I want to talk about House Bill 1005. You've likely heard lots of conversation around our state around issues related to bond and bail. This is different than that. This has to do with conditions that are actually placed on bond. So this law basically says that if you are arrested for a human trafficking and certain prostitution related offenses, there are additional things that are going to be required when you execute your bond. So looking at your driver's license, at your state issued ID, making sure we have a good address, ID number, what is the state that issued that, basically collecting more information on those individuals that have bond related to those specific offenses. In addition to requiring additional information, it also expands some of the bond conditions that exist. So when somebody is out on bond, there can be a number of conditions that are placed on that bond. So this has to do specifically with that defendant's ability to communicate with an alleged victim or to go near locations, residences, other places that that alleged victim might often frequent. So that's a common bond condition in certain sexual offenses. You know, that defendant can't have direct contact or go into those areas. So what this law does is it increases the age. Before it was under 14 to now under 18 for certain sex-related offenses. So we are going to automatically have these bond conditions when we have a victim who's under 18 as opposed to under 14. And in addition to that, it actually extends those same bond conditions to human trafficking cases across the board, regardless of the victim's age. So it's not limited specifically to minors or to young children. On sort of the opposite end of the spectrum from early in the criminal justice system on bond is parole eligibility. And this has to do with individuals that have been convicted and at what point during their sentence they might be eligible for release on parole. So as background, before this session, the current parole eligibility for human trafficking and continuous human trafficking, which I should clarify, continuous human trafficking is just human trafficking that has occurred multiple times in a short time period. It's an enhanced offense similar to continuous sexual abuse versus sexual abuse. But for both of those offenses, individuals are not eligible until their actual time served equals 1/2 of the sentence. So that means we don't take into consideration any good conduct. The literal calendar time has to be half of your sentence or 30 years, whichever is less, as long as there's a minimum of 2 years. That was the current provision prior to this session. After this session, those that are convicted of continuous trafficking, multiple trafficking offenses in a short period of time, if it's continuous trafficking of a child, ineligible for release on parole altogether. So complete ineligibility for continuous child trafficking. For other forms of child trafficking, you know, that aren't that continuous level, it's just one time that's being proved or not within the parameters of our continuous statute, they will also be ineligible for parole, except that there is this exception built in through the statute that basically says if all parties come to agreement in a written form, so we have, first of all, the defendant has to plead guilty, but then we have a written agreement between the defendant, the defendant's attorney, and the prosecutor. If they all agree in writing and the judge then makes an affirmative finding of that, they could be eligible for release on parole based on those old standards, the half of their time actually served or 30 years. So it's kind of interesting. It provides a little bit of flexibility for the prosecutor somewhat to have discretion whether or not they want to agree to that defendant having the eligibility for release on parole. But that is going to make an impact for those that are convicted for child trafficking related offenses. Now, neither of those provisions I just discussed were task force recommendations. We're hopping back into some now that are in the omnibus that were task force recommendations. This first one around the definition of coercion is actually one of those cleanup provisions that I talked about earlier. So take your mind back to the Trafficking 101 and what's required for trafficking. A person was trafficked, and if it's an adult or if it's any form of labor trafficking, we have to have force, fraud, or coercion. Force, fraud, or coercion has to be shown for adult sex trafficking or for adult and child labor trafficking, okay? Now, the problem with this is that we have a definition of coercion that applies across the penal code, but we also have a definition of coercion that is specific to the trafficking statute. So it basically says that coercion for the purposes of trafficking also includes controlling somebody's identification, forcing them to be on drugs, or forcing them to drink alcohol into excess, using that as a method of control, withholding access to those drugs or alcohol in order to manipulate them. Those are all specific forms of coercion that are specifically called out in our trafficking statute. However, before this session, that definition of coercion only applied to adult sex trafficking. So it said if an adult sex trafficking victim was coerced through one of these methods, then this definition of coercion applies. However, it probably, you can guess, looking at these, that these are also forms of coercion and manipulation that are also used against labor trafficking victims, especially control of government records and identification documents is a common form of manipulation for labor trafficking victims. So House Bill 1540 and also House Bill 3521, they took this existing definition of coercion for trafficking and basically said it applies to all forms of trafficking. So these same forms of coercion and manipulation can be used for labor trafficking or for adult sex trafficking. And I think this is really important because it addresses a misconception that a lot of people have that haven't been in this space, and they think that all trafficking is brute force. It's brute violence. It's coercion that is really highly threatening and manipulative, and people are being injured in the process. But there has been a lot of research that supports the fact that a lot of manipulation in trafficking cases is actually non-physical violence, non-physical coercion. I don't know if you've heard of the Human Trafficking Institute. They do a lot of work nationally and abroad, and they had a report that came out that looked at every federal human trafficking case that had been filed. Shout out, by the way, to Texas for leading the way even on the federal side of things in those trafficking prosecutions. But they found that in all of the cases for trafficking around the nation, for federal cases, traffickers were more likely to control victims using non-physical methods of coercion. 59% of the tactics that were used were actually non-physical, withholding documents, withholding pay, making those threats. So it's important to recognize, not just as law enforcement and prosecutors, but as potential jury members, as general community members, that trafficking is not always what the media tells us that it looks like. It's not always bound in chains and being beat and bruised all over the place. Another recommendation from the task force was this use of drink solicitation as an investigative tool. Basically, drink solicitation happens, you have bars or establishments that obviously have alcohol for sale, but drink solicitation happens when the customers of that establishment are being encouraged to purchase drinks for the staff of the establishment. So they're not only being encouraged to buy drinks for the staff, but they're being encouraged to do so at a significantly marked up price. So you're paying for drinks at a marked up price for the staff of this establishment. And what we have found in working with our partners at TABC is that this is very often a gateway into various criminal activity. That drink is being purchased at a marked up price and is leading to acts of sexual exploitation, acts of prostitution, acts of trafficking. And so there's a big concern that this could be a gateway into some of that other illegal activity. Drink solicitation is already illegal. It's something that existed in our statute. But what this new law does is basically makes drink solicitation one of the offenses that can trigger automatic denial of a permit or a license application. So as these businesses are seeking to reapply for their alcohol license, that finding of drink solicitation as automatic grounds for denying that application. And I also wanted to credit TABC. Last legislative session before in the 86, there was actually a law that was passed that explicitly said one of the primary responsibilities of TABC would be to have zero tolerance policies around trafficking in its licensed establishments. And they have taken that very seriously in terms of being a partner. They often have an opportunity to get in to these locations to inspect issues related to alcohol and liquor licensing, that there might not be a reason otherwise to get into those places, and so they can be a unique and key partner in sort of opening up some of those investigations. And just to highlight that, I wanted to point out, before I came to Austin, to the governor's office, I was in Houston for many years, and I remember, you know, our state law passed in 2003. Around 2004, 2005, one of the very first cases of human trafficking that unfolded in our state was based around a series of cantinas in the Houston area. And TABC was actually one of the first to uncover that, because as they're in these establishments doing inspections, they're seeing things like female workers that are going into a bathroom and never coming out. And lo and behold, there's actually a door back there that leads to a separate part of the facility where those transactions and exploitation were taking place. But it also highlights the fact that this control of access to alcohol can be used as a form of manipulation as well. There were, I think, over 100 young women that were recovered out of those establishments ultimately, but one of the things that was commonly reported by them was being forced to have these drinks with the customers in these establishments, to the point of having serious intoxication, dangerous levels of intoxication. And so it can also be used as a form of violence as well, which is something I think I wouldn't have normally thought of unless I was familiar with that case. And so this drink solicitation can be one tool that's used administratively to help prevent some of these businesses from operating. I wanted to talk about something I'm personally really passionate about, and that is reducing demand for this activity in our state to begin with. This ultimately made its way into the Task Force Omnibus Bill 1540. It was one of the task force recommendations. It was originally filed in a separate bill that didn't ultimately end up moving, but it made its way before session was over into this bill. And this bill is really focused on how we address demand. How do we address buyers in our state? So I want to hope you'll hang with me. That we're getting towards the end here. Outline a little bit of the history of how we treat buyers in our state. So up until 2019, which was not so long ago, if you were arrested as a buyer of prostitution or as someone that was being prostituted, you were subject to the exact same penalties in the penal code. We made no distinction for purposes of that punishment. It is the same penal code offense, 4302 prostitution, whether you are seeking to purchase or whether you're being sold for sex. And so for both of those parties, we had a sort of enhancement level strategy around this. So on the first offense, it's a Class B misdemeanor. It ramps up to a Class A for the second and third. And then by the fourth offense, it's a state jail felony. So treated exactly the same among those two parties. What we found was, as we tried to look at data around this issue, it became very difficult because they were tied to the same statute, there was no way to cleanly disaggregate how many prostitution arrests were of buyers and how many were of those being arrested as prostitutes. And you could read into the case files and find out that was very time intensive. You could even potentially, look at some basic demographics, but before I came here, I was on a research team in Houston where the Houston Police Department gave us access to their prostitution arrest records. And we read through those and categorized them as buyers versus sellers. And what we found, at least in Houston, was we couldn't look at just male versus female because every single buyer that we found was male, but every single prostituted person was not female. There were a number of men and boys being exploited as sellers as well. So there was no clean way to disaggregate that, which doesn't incentivize us to take proactive efforts to treat these two groups any differently. You can imagine that if you're a person in a life of prostitution, you're much more likely to have encounters with law enforcement than a potential buyer. So as you have these enhanced penalties, what we found in our research was that you were much more likely to encounter law enforcement 4 or more times and thus reach a state jail felony as a person in a life of prostitution than you were as a buyer. You were just much less likely to be arrested. as a buyer. And to their credit, when Houston started tracking that data and they started seeing those numbers, they made significant shifts in their community and how they track that data and how they do their proactive responses. So what began as roughly a 90% to 10% ratio of individuals arrested as prostitutes versus buyers became much closer to 50-50, and at one point was even more likely to be arrested as a buyer than as a person engaged in prostitution. So it's important that we know how to disaggregate these things. So I digress back to our timeline. Prior to 2019, that's how things were treated exactly the same. In 2019, there was actually a distinction that was made within the prostitution statute. We didn't create a new statute, but we just tried to have better distinction in that prostitution statute. So while those arrested for selling sex were still facing the old penalty enhancement scheme, and actually they also were given more access to community supervision and to specialty courts to connect with services. What happened with the distinction in 2019 is that we ramped up the penalties against buyers. So last session, as of September, after that last session, on the first offense of purchasing, it was a Class A misdemeanor. And on the second offense, it was a state jail felony. So you can see ramped up significantly more quickly than it had been in the past. And I should point out that this is all talking about purchasing from an adult. It was always the case already that if the person you were soliciting or purchasing was a minor, that would be a second-degree felony, and that's still the case. So this is talking about prostitution with an adult. What happened this session is that the legislature decided to better disaggregate, to better split up the acts of purchasing versus selling, and to also ramp up the penalty scheme as well. So what we had happen was the creation of an entirely new provision in the penal code that is now solicitation of prostitution. I think it's 43021, is relevant only to buyers. So all of the data we have under that statute will be specific to buyers. The old 4302 will continue to be the more traditional response to prostitution. But under this new statute that is applicable only to buyers, first-time buyers are actually going to be facing a state jail felony. This is a pretty significant enhancement over just 2 sessions ago, where you were facing a Class B misdemeanor. So I think there are going to be significant implications for communities that are doing demand reduction work as law enforcement and prosecutors, but also significant implications for our public awareness efforts. I think one of the reasons that demand has continued to thrive is there's just not much perception of risk when it comes to purchasing. First of all, you were not likely to be apprehended or arrested. It just wasn't common. And second of all, if you did, up until a couple years ago, you were facing a Class B misdemeanor and were unlikely to be rearrested. And so there wasn't a lot of fear around that. I think now with the state jail felony on that first time, there's an opportunity to improve community awareness about the role of buyers in trafficking and exploitation, and also to instill some of that deterrent effect that there is a lot more risk associated with this than there was before. So again, first time offense, state jail felony, second offense, third-degree felony. And if you remember from those school safety zone laws that we talked about earlier, there's the possibility for some additional enhancements if that's committed near schools as well. And so again, significant penalties associated with demand this session. We are just a few minutes out from the time goal that I had set for myself when we started out. So I want to share with you our contact information you have earlier in the slide deck. And again, we'll be sharing this recording if all goes well, that regional map that shows the RA in your community. So their contact information is listed here. When we send this out, we're also going to be sending a couple of resource documents. One is going to be a chart from the State Human Trafficking Prevention Task Force that actually gives explanations of each of their recommendations and the bills that they ultimately passed in. So if you are more interested, for example, in some of those cleanup bills that we didn't talk about, you'll be able to read about those there. And we're also going to have a resource document from our team that shares all of these highlights that we talked about today, but then also has a chart that identifies some other bills that passed that are within the realm and world that you might be interested around trafficking, but weren't specific enough to be listed here. So, for example, one off the top of my head, there was, you might recall, an emergency item around increasing access to broadband internet in rural communities. And along the way, as that was being passed, there was a provision embedded in that the council working on that is going to study the effects of access to pornography and look at how we can mitigate that in our state as we're increasing access to internet connections. So that's just an example of something that is kind of in the universe. There are too many issues around juvenile law, family law, sexual abuse, child abuse, and others to go through all of them, but some of those will be listed there. So with that, I'm going to take a look and see if we have any questions that came in. Hopefully, this isn't going to freeze up on me. Let's see. So there's some questions around some of the penalty enhancements that are being faced around like RTCs and school zones. And they didn't ask about this, but you might have also wondered around the sexually oriented businesses, whether or not there are provisions in there to make sure that it's not the youth that are being punished for that. By and large, yes, there are protections in there to make it clear that they are not the ones that are meant to be the target of this. It's a good question and an implication to go back and look at. I can't remember for every single one of those drug-free, gang-free, child safety zones, no trafficking zones, that is built in. But by and large, and I know especially for the sexually oriented business, the goal is to put the burden on the business and on the perpetrator and not to minors and potential victims in those. Let's see. And I apologize because some of these questions were referenced in real time, so I don't have the context for them. I'm seeing. There's a question about some of the posters that are required to be posted. Transportation hubs, yes, transportation hubs are defined in the statute. And so I can't remember every single location, but there are things like bus stops and rest areas and that sort that are identified in that statute that are subject to that. TxDOT is doing a lot of work around that. Hotel posters are employee facing and not for the public to report as well. That is correct. That is just the language of the statute, and I won't get into for any of these. I would say how the sausage was made. I'm Cajun, so you really don't want to know how the boudin was made on some things, but that is the language that was agreed upon. I think at one point there may have been a provision that considered public facing in hotels. There are some other states that do that, but that never made it into any of this legislation here. When we do our outreaches, oh, and it looks like the questions froze there. Give me 1 second. Jordan or Andrea, can you let me know if you're still able to hear me? Because the question box froze on my screen. I might need help.
I can read it.
Getting to some other questions. Yeah, did we have any other questions that came in?
Yeah, the outreach question says, when we do our outreaches to all the locations that require signage and training, who do we report non-compliance to?
Oh, that's a good question. It's going to depend somewhat on which of those that you're looking at. As I mentioned earlier, depending on the location, may impact which state agency has oversight for that. So for example, our State Department of Licensing and Regulation is the one that looks at and enforces posting in massage schools and cosmetology schools and salons, that sort of thing, as opposed to this new hotel training that is going to be largely regulated by the Office of the Attorney General. But there are also opportunities in most of these for local law enforcement to initiate that. you would want to look at the specific signage that your community is doing outreach on, and this is something that our team can help down the road through our RAs. If an interest in your community is making sure that you have signs up in all of these locations based on the timeline, we can help with some of that communication down the road and making sure that there's clarity on which locations that's required, which signs have been approved, and how to report some of those.
Okay, we have quite a few that have come in the last couple of minutes. Did a law pass requiring signs for school districts?
So the signage for school districts is just that no trafficking zone. So that is more of a sign that's like on the perimeters of your school grounds that is like, you know, this is a no trafficking zone. There are penalty enhancements under these provisions of the penal code. It's not a sign like the others that we talked about in the sense of if you are a victim and need support, or if you want to report, it's not that kind of sign that's required. Certainly there might be opportunities for schools to explore that. And honestly, I think a lot of people don't realize some of the other regulations for schools around trafficking, such as mandatory educator training, policies, student prevention education. So if you are in a community that's doing some, you know, support for schools as you help them be aware of these no trafficking zone enhancements, it might be an opportunity to talk about some of those historic ones. But no, there's school posters for child abuse generally, but not for trafficking, not that is student facing.
Okay, since buyers are now state jail felonies, that would allow for Chapter 59 seizures?
So that's a great question that is a little outside of my expertise, since there are so many issues that trafficking touches. I feel like I'm a jack of all trades, but a master of none. But I do know that one of the talking points from some of our DA's offices and prosecutors that supported this enhancement was that the enhancement to a state jail felony would create more opportunity on some of those seizures. So that is certainly something that I think is accurate. I would have to do more research to double check, but I have heard from some prosecutor partners that they are intending with this enhancement to utilize those seizures under Chapter 59. And I'm actually seeing some of the questions come up now, Jordan, so I think I can go through here. One of the questions is about some bills that didn't pass, and unfortunately, no, I just don't have any insight that I can provide on that. I wish that I did. Let's see here. Some questions around the enhancement for sexual abuse. I believe the question is whether or not that enhancement related only to continuous sexual abuse. From my recollection, that is correct. But again, I'm going to go back to the caveat at the beginning. Not yet well versed enough in every single one of these to say with confidence. So I would double check the language of that. But if I remember correctly, it was just the statute that was previously continuous sexual abuse of a young child being expanded to disabled individuals. But it may have been broader than that. I just can't recall off the top of my head. People asking about the recording. Yes, it's frozen a couple of times on my end, but I'm hoping that doesn't mess up the recording. If the recording does mess up, we'll at least make a PDF of the presentation available to all of you. Questions about how to access the signage. So most of the laws in Texas that get passed go into effect September 1st. So there is some you know, flexibility there. For example, Senate Bill 315 we talked about went into effect immediately. Some of these signage requirements, they already exist. So all of those that were in the darker color, they already exist, and each of those agencies that oversee them have model signs that are posted. So for example, TABC has a model sign for alcohol and bar and restaurants that have certain permits. And TxDOT has for some of the transportation hub. The OAG actually is responsible for the signs that currently exist in sexually oriented businesses. So all of those are available there. I think as we move forward in the rulemaking for that consolidation statute that I talked about, you're going to see some new model signage come out. And so the task force and the coordinating council will be working on that. My guess is that it will be linked in the rules that are associated with that, but also linked on those websites. And so again, that's something that as we get into some of the implementation of these policies, we can continue to roll out to folks that are interested. But some of those are months away before there are updates that are made to those signs. Some of this is just really kind feedback from some of you. Let's see. Jordan, I'm sorry, it froze for me again. We might have time for just one or two more. We're a little over our target.
Let's see, where can we find why the victim testimony protection bill was rejected?
Oh, so, I mean, unfortunately, I don't really think you're gonna, I'm having trouble recalling. When we send out the resource document, you'll be able to see the bill number that was filed in, since it wasn't part of the omnibus bill. And you'll be able to look up that bill on a website called Texas Legislature Online. I honestly don't recall how far it made it into the process. So if it made it to a committee hearing, you may hear some of the concerns that came up in the committee hearing. But if not, then it's going to be hard to find much more information. Sometimes there are bills that never even make it to the hearing level. That's actually pretty common. But if it did make it to that level, that website will have that testimony, and there'll also be a link to a helpful document from the House Research Organization that actually outlines for any of these bills. If you want to look, it says, what is the goal of the bill? What did the supporters say? What did the critics say? So that could be a really helpful resource, not just on that, but on all sorts of other issues as well. Let me see. I'm just going to see if we have time. You guys are I am just so glad that there were so many good questions that came up. I don't know if that's bad on my end that I didn't explain well, or if it's great on your end that you have so much interest in. I'm gonna hope for the latter. Let me see. Actually, it froze again, Jordan.
Yeah, I got it. Does the new TABC law mean that all bars / dance halls will be 21 and over, or just if they are considered SOBs? Okay, well, it looks like Todd froze, so we are going to just go ahead and end the webinar. Thank you everyone for joining and for asking so many different questions. Like we mentioned, we'll get everybody the recorded webinar, as well as the handouts that Todd mentioned, and the presentation itself in a PDF format. So thanks again, everyone. Keep an eye out for our next webinar that will be happening in August. Everyone have a great day. Thank you.